Good evening, and welcome to the Rachel Maddow Show. I'm Rachel Maddow, and tonight we're diving deep into a story that feels like it's ripped from the pages of a constitutional thriller, but it's happening right now, in real time, in the heart of American democracy. It's December 26, 2025, and the political landscape is ablaze with what could be the final chapter in the long, tumultuous saga of Donald Trump's presidency. We're talking about a brand new impeachment firestorm ignited by allegations of blatant court defiance. And at its core is a question that strikes at the very foundations of our government. If a president ignores federal court orders and Congress wavers on impeachment, is there any meaningful check left on executive power? Let me set the scene for you. Just days ago, Democrats in the House of Representatives issued a stark ultimatum. President Trump must resign immediately or face impeachment proceedings as early as Monday. This isn't hyperbole. It's a direct response to what they describe as an abuse of power, culminating in his inflammatory rhetoric at a pro-Trump rally that they say incited the violent attack on Capitol Hill back on Wednesday. But this impeachment push isn't just about that rally, though that's incendiary enough. No, it's building on a pattern of behavior that's been simmering for months, even years. The Trump administration's alleged systematic disregard for the rule of law, particularly when it comes to federal court rulings. Legal watchdogs, including groups like Free Speech for People, have been sounding the alarm through their Impeach Trump Again campaign. They've compiled a damning list of instances where Trump officials have thumbed their noses at judicial orders. We're talking about withholding billions in foreign aid, specifically $2 billion, that courts explicitly ruled must be released. Injunctions against freezing federal assistance, ignored. Deadlines for testimony, like the one for Office of Personnel Management Acting Director Charles A. Zell, set for March 13, 2025, in a case involving mass terminations of federal employees, blatantly missed. These aren't minor oversights. They're deliberate acts that paint a picture of an executive branch treating the judiciary not as a co-equal partner, but as an annoying suggestion box. Now, to understand why this matters so profoundly, we have to zoom out and look at the constitutional architecture our founders built. The separation of powers isn't just a fancy phrase from civics class. It's the bulwark against tyranny. Article 3 of the Constitution establishes the judiciary as an independent branch, empowered to check the executive. When a president defies court orders, it's not just a policy spat, it's an assault on that structure. Judges can't march into the White House with handcuffs. They rely on the executive's good faith to enforce their rulings. But what happens when that faith is shattered? That's where Congress comes in, with the impeachment power as the ultimate remedy. Enter House Resolution 353, introduced back on April 28, 2025. This isn't some fringe effort. It's a formal impeachment document laying out 7 articles against Trump, including obstruction of justice, contempt of court, and, most strikingly, tyranny. Yes, tyranny. The resolution accuses him of violating court-sanctioned settlement agreements, undermining the powers of Article 3 courts, and essentially placing himself above the law. The tyranny charge is loaded with historical weight. It echoes the fears of the framers, who designed our system to prevent any one person from becoming a king. By framing Trump's actions this way, advocates aren't just playing politics. They're invoking the Constitution's deepest principles. But here's where the plot thickens: politics. Remember the December 11, 2025 vote on a separate impeachment resolution introduced by Representative Al Green. The House voted 237 to 140 to table it, effectively shelving it for now. What's telling is the breakdown. 47 Democrats voted present, a procedural maneuver that's basically a way of saying, I don't want to touch this with a 10-foot pole right now. This reveals a deep fissure within the Democratic Party. Some, fired up by the mounting evidence of court defiance, want to charge ahead with impeachment as a moral and constitutional imperative. Others are haunted by the ghosts of past impeachments, Trump's 2 previous ones over Ukraine and January 6th, and fear voter fatigue or a backlash that could cost them seats in 2026. Meanwhile, Republicans have locked arms in unified opposition, portraying the whole thing as partisan witch hunting. They argue that the administration's actions are legitimate exercises of executive privilege, not defiance. But the facts, as documented by the courts themselves, tell a different story. Judges in multiple cases have issued rulings only to see them flouted. In one Rhode Island case, a judge even issued a stern warning. "I meant what I said when I told you to release those federal funds. Please follow my order." Yet compliance, crickets. This isn't abstract, it's concrete. The $2 billion in frozen foreign aid isn't just numbers on a ledger. It's aid meant for allies, withheld in direct violation of court injunctions. The missed testimony deadline for Charles Azell, that's obstructing the judicial process itself, preventing courts from getting the facts they need to rule on mass firings that could affect thousands of federal workers. These specifics build a case that's hard to dismiss as mere disagreement. It's a pattern, court says do this, administration says no thanks. And let's talk about the broader implications. If Trump gets away with this, what message does it send to future presidents? That court orders are optional? That the judiciary is toothless? The Brennan Center for Justice has analyzed this exact scenario, noting that courts have limited tools, contempt citations, fines, maybe even arrests, but enforcing them against the executive branch is a paradox. The marshals who would carry out arrests work for the executive. Tuskegee. It's like asking the fox to guard the henhouse while also punishing itself. This firestorm crystallizes a live question for voters. Do we still believe in checks and balances, or has presidential power become unchecked? As we head into the new year with impeachment looming, this isn't just about Trump, it's about whether our democracy can self-correct when pushed to the brink. Stay with us. We've got more segments ahead where we'll unpack the details, the strategy, and the stakes. This is The Rachel Maddow Show. Welcome back to The Rachel Maddow Show. I'm Rachel Maddow, and we're continuing our deep dive into the impeachment crisis engulfing President Trump. In our first segment, we laid out the big picture, allegations of court defiance fueling a new push for impeachment with House Resolution 353 at its center. Now let's get granular, because in stories like this, the devil and the constitutional crisis is in the details. We're going to dissect what this court defiance actually looks like, instance by instance, and why these specifics make the case for impeachment so compelling. Start with the $2 billion in foreign aid. This isn't some obscure accounting error. It's a blockbuster example of executive overreach. Multiple federal courts ruled that the Trump administration could not freeze this aid, funds allocated by Congress for critical international programs. Why does this matter? Because it's not just about the dollars. It's about Congress's power of the purse. By defying the courts, Trump isn't just ignoring judges. He's usurping legislative authority, turning the executive into a one-stop shop for policymaking. Then there's the Charles Azell testimony fiasco. Azell, acting director of the Office of Personnel Management, was ordered by a federal judge to appear in person by March 13, 2025, in a lawsuit over mass terminations of federal employees. This was no vague request. It was a specific deadline tied to a case alleging wrongful firings that could upend lives and government operations. The administration's response? They didn't produce him. Period. This goes beyond policy. It's obstructing the judicial process at its core. Courts rely on testimony to uncover facts, evaluate claims, and deliver justice. By stonewalling, the executive is essentially blinding the judiciary, preventing it from doing its job. But wait, there's more. Impeachment advocates point to a series of injunctions against freezing federal assistance that were similarly ignored. These weren't one-off rulings. They came from multiple courts across the country. In each case, judges issued injunctions, legal halts, to protect programs and funds. The administration's pattern of non-compliance suggests not mistakes or misinterpretations, but a deliberate strategy. As one legal analyst put it, this is treating court orders as suggestions, not mandates. The systematic nature elevates this from isolated incidents to a full-blown assault on the rule of law. Now, let's turn to House Resolution 353 itself. Introduced in April 2025, it outlines 7 articles of impeachment, each building on this defiance. Article on contempt of court? It cites violations of court-sanctioned settlements, like those in environmental and immigration cases where agreements were reached only to be flouted. Obstruction of justice? Tied directly to refusing testimony and withholding documents, echoing the Watergate-era scandals that nearly toppled Nixon. But the standout is the Tyranny article. This isn't everyday legal jargon. It's a direct nod to the framers' nightmares. The resolution accuses Trump of undermining the powers of Article III courts and treating separation of powers as an obstacle to be ignored. It's framing this not as politics, but as a fundamental threat to the Republic. Remember, this resolution didn't emerge in a vacuum. It builds on the work of groups like Free Speech for People, who in their campaign statement listed these examples with damning specificity. They're not just throwing accusations, they're providing a roadmap, handing Congress a ready-made case. Judges, for their part, have been documenting this non-compliance meticulously. In one case, a Rhode Island judge issued a pointed reminder: follow my order. No threats of contempt yet, but the warning shots are firing. Politically, this is where it gets messy. The December 11 vote to table Al Green's separate impeachment resolution, 237 to 140, with those 47 Democratic presents, highlights the strategic divide. Hardliners see this defiance as an impeachable offense now, drawing parallels to historical precedents like Andrew Johnson's defiance of Reconstruction laws, which led to his impeachment. Pragmatists worry about timing. With 2026 midterms looming, does pushing impeachment energize Trump's base more than it rallies Democrats? And after 2 failed impeachments, is there impeachment fatigue among voters, viewing it as theater rather than accountability? Republicans, meanwhile, are dug in. They frame this as executive prerogative, not defiance, appealing to their base's distrust of activist judges. But the court's records undercut that narrative. These aren't partisan hacks. They're federal judges appointed across administrations, issuing rulings based on law, not politics. Broader context. This defiance dovetails with other controversies like alleged violations of transparency laws on Epstein files or using the DOJ politically. It's a mosaic of an administration viewing laws optional. Legal scholars warn that if this normalizes, future presidents, Democrat or Republican, will follow suit, eroding judicial authority permanently. As we wrap this segment, consider the paradox. Courts can rule, but enforcement relies on the executive. When that fails, impeachment is the failsafe. But with Congress divided, the pressure builds like a pressure cooker. In our next segment, we'll explore the Democratic schism and Republican strategy. This is The Rachel Maddow Show. Stay tuned. Good evening once more from The Rachel Maddow Show. I'm Rachel Maddow, and if you've been following along, you know we're in the thick of dissecting this impeachment firestorm sparked by President Trump's alleged court defiance. We've covered the big picture and the nitty-gritty details. Now, let's pivot to the politics. Because in Washington, constitutional crises don't unfold in isolation. They're shaped by calculations, divisions, and the raw math of votes. At the heart of this is a Democratic Party torn between duty and strategy, and a Republican bloc standing firm in defense. This segment, we'll unpack why the Democratic split matters, how Republicans are responding, and what it all means for the viability of impeachment. First, that December 11 vote. 237 to table Al Green's resolution, 140 against, and 47 Democrats voting present. Those presents are the tell. In congressional parlance, it's a dodge, a way to avoid a firm yes or no. It signals unease, a fear that supporting impeachment could backfire politically or that opposing it might alienate the base. This isn't new. Democrats have been here before. During Trump's first impeachment over Ukraine, unity was hard-won. The second, post-January 6th, was more visceral, but still didn't yield a Senate conviction. Now with a third looming, some Democrats whisper about impeachment fatigue, voters weary of the process, seeing it as endless partisan bickering rather than justice. Strategically, the divide boils down to timing and risk. Firebrands like those backing House Resolution 353 argue that court defiance demands immediate action. The evidence is there. Documented violations from the $2 billion aid freeze to ignored testimony orders. Waiting, they say, normalizes lawlessness and weakens Congress's check on the executive. But moderates, especially in swing districts, eye the polls. A third impeachment without removal could rally Trump's supporters, framing Democrats as obsessed with takedowns over governance. With economic pressures and other crises in 2025, is this the hill to die on? This schism isn't just internal drama. It hands Republicans a narrative gift. GOP leaders have pounced, calling the push partisan overreach and defending Trump's actions as protecting executive authority from judicial activism. Their unity, every Republican voted to table Green's resolution, ensures impeachment stalls in the House. Without bipartisan support, it's dead on arrival in the Senate. But here's the irony. By stonewalling, Republicans are betting voters prioritize loyalty over accountability, even as courts pile up evidence of defiance. Let's connect this to broader patterns. Trump's rhetoric has long attacked the judiciary, calling judges corrupt or biased when rulings go against him. This delegitimizes courts, creating a permission structure for defiance. Supporters hear fake judges, so why comply? It's a 1-2 punch. Rhetorical assault plus practical noncompliance, eroding trust in institutions. Legal experts like those at the Brennan Center highlight the enforcement dilemma. Courts can cite contempt, fine officials, or order arrest, but who enforces? The executive. It's a constitutional catch-22, pushing the onus to Congress. If lawmakers hesitate, the crisis deepens, testing whether separation of powers is enforceable or just aspirational. Looking ahead, 2026 midterms loom large. If Democrats push and fail, it could cost seats. And fail, it could cost seats. If they don't, they risk base disillusionment. Republicans, by contrast, calculate that defending Trump solidifies their coalition, even if it means overlooking constitutional norms. This political tango underscores the stakes, not just Trump's fate, but democracy's resilience. When evidence mounts but action falters, does the system work? In our next segment, we'll explore constitutional implications and historical parallels. This is The Rachel Maddow Show. Back on The Rachel Maddow Show, I'm Rachel Maddow, and we're pressing forward into the constitutional heart of this impeachment saga. We've examined the defiance details and political divides. Now, let's elevate to the framers' vision. This isn't just about 2025 politics. It's about whether our 1787 blueprint can withstand a president who treats courts as optional. We'll draw historical lines, assess long-term damage, and ponder,